Hello and welcome back to Heights Library's podcast, Unpacking 1619, where you can explore the interviews we've collected with scholars from around the country, in which we unpack topics relating to race in America. I'm your host, John Pichet, and I'm thrilled to share these interviews with you here. On today's episode, I'm joined by Daniel Harawa, Professor of Law and Director of the Federal Appellate Clinic at NYU Law, to discuss his article, Lemonade, a Racial Justice Reframing of the Roberts Court's Criminal Jurisprudence. Professor Harawa points out how the court has recently issued a series of decisions addressing racism in the criminal legal system. Peña-Rodriguez versus Colorado and Flowers versus Mississippi. Both teach that race history matters. Those who discriminate must be held to account, and institutional practices can no longer perpetuate racism. While not perfect, these cases offer opportunities to push the court to enforce the law with equity and equality. Here's our discussion from July 17, 2025.
Hi, I'm Daniel Harawa, and I'm a professor of law at NYU School of Law.
Well, thank you for joining us today. We're going to be talking about the Roberts Court and specifically a paper you wrote called Lemonade, a Racial Justice Reframing of the Roberts Court Criminal Jurisprudence. Can you explain what the purpose of the paper is and what brought you to explore these issues?
Yeah, so one of the courses I teach at NYU is a federal appeals clinic. And that means we litigate criminal cases and civil rights cases in federal courts of appeals across the country. And part of what worried me is that as we see the court move to the right and issue more criminal defendant civil rights unfriendly cases, that people would start to give up hope and people would stop thinking about how to litigate innovatively and trying to push the law towards more progressive ends. And I would do trainings and talks across the country where I would hear, well, we can't experiment because the court's so bad. We can't make this argument because the court's so bad. And it just felt like we couldn't stay static, that we had to keep pushing the law to recognize all of us and all of our various kind of permutations. And so that was really the driving impetus for the article, is one, just hopefully giving hope to other people out there that maybe we can find good things amidst the bad. And just as importantly, because our clients and our client base deserves us to fight for the law to recognize them fully and equally.
Well, it's an interesting argument you developed because, as you're saying, this kind of the silver lining inside of what could be described as storm clouds. Could you give us a background before we get into how you develop your argument about those silver linings? Could you give us a background of what the Roberts Court has set out to accomplish and what their colorblind ideology is and isn't?
Yeah, so it's a great question. And it truly is me trying to find a silver lining because I can be very pessimistic. So I needed to write something to give me hope and inspiration. So John Roberts, interestingly, and it kind of traces back to his history as a government lawyer in the 80s, has always been fixated on the use of race in the law. And for whatever reason, that has just been his bugaboo issue. And it started in the voting rights context, where he was very kind of against the Voting Rights Act and how the Voting Rights Act was designed to ensure a full and actual multiracial democracy. And for whatever reason, the project felt anathema to him. And so you see from the moment he gets on the court, starting from a case called Parents Involved, which is a school desegregation case, he comes up with this line that the best way to stop discriminating by race is to stop discriminating by race. And what he means by that is we just can't talk about it. We can't see it. And since this article came out, we have the Student for Fair Admissions case, which is the affirmative action case in college admissions where he came up with a similar line trying to make a similar point. And so, to his mind, I think he thinks that any kind of racial classification in the law is odious. And therefore, what he would like to do and what his court has worked to do is kind of strip race from jurisprudence altogether, um, as if we don't have strides to make in terms of ensuring racial equity and equality in the country. Um, but one place where it hasn't surfaced as frequently, at least as kind of rank colorblindness idea, is in its criminal jurisprudence, which is really interesting to me, given that criminal law is one of the areas of law where you see or where you hear about race getting talked about most frequently. Like we can tick off all the ways that there are disparities in kind of every aspect of the criminal legal adjudication process. But you don't really hear the court talking about colorblindness in the same way. So it was kind of a combination of I see the court trying to strip race away from every area of life, but in this one area of life, they somehow haven't gotten there yet, right? And so, how can we come up with ways to ensure that that stripping, once they get to criminal law and criminal procedure, once they get there, they don't just do that same stripping that they've done everywhere else or that they're trying to do everywhere else. So that was really the driver behind the paper, is kind of carving out this area of law where even if you tell me that race doesn't matter in all of these other aspects, it matters here. I mean, just on the ground, we know it matters. If we read and look at the news and listen to people, we understand it matters. But jurisprudentially, it matters too. And so that's the argument the paper was trying to make over the course of however many pages it is.
Right. And I think you do a very good job of setting out where the court is ideologically, and then also how those decisions can be used to open avenues of maybe resistance or pushing the law forward. And I would like you to talk a little bit more about the Roberts Court, unfortunately, and what their ideology is in because on one hand, they, as you say, they want to acknowledge race in a way, but they deny a lot of the racial history. So we hear that they're originalists. They want to look at how the law was written originally and all this. And everyone's a constitutional historian now. But they start racial history in Jim Crow, and they deny if they acknowledge that race exists, they deny systemic racism.
Yeah.
So could you talk about how they get to those two conclusions?
Yeah, so it's a really interesting move that the court makes, is that on one hand, they see the idea of racism as being kind of this Jim Crow style of racism, right? Where there's no colored people allowed to drink from the water fountains using the N word, just kind of this this idea of racism that is trapped in the 50s and 60s that doesn't hopefully exist most places in the same way, although we can talk about whether we're seeing kind of a retreat to the old style racism. And so the court seems to recognize that when that happens, we need to step in and fix it. And the court also seems to recognize that slavery happened. um, but it's really interesting that they recognize that in ratifying the Reconstruction Amendments, the 13th, 14th, 15th Amendments, that Congress, the country, was trying to undo the evils of slavery. But then they seem to kind of just say, and they did, right? And so it's like, so we fought a war that tore the country in half. We passed three constitutional amendments. The third, the 15th, was passed because states were still disobeying the promise and spirit of the 13th and 14th Amendments. And somehow those amendments just did away with the centuries of enslavement that happened before them. And so it's strange. You see this period of, we acknowledge that slavery happened and that we were trying to undo some ills from slavery. We acknowledge that Jim Crow happened, but everything between is just kind of lost on the court, including the fact that just passing an amendment won't fix a problem that our entire country is built upon, right? And so it's weird that they are, I mean, they're not historians, right? To be clear. And the history they choose to give life to is so cherry picked for their own worldviews that it can become a little disparaging when you think about kind of how being disadvantaged for centuries and then that's just slavery, but think about all of the way the law discriminated against people legally for decades afterwards. And for that not to matter at all in any kind of systematic way, it's just, it can really lead you to be, I mean, rightfully in many ways, discouraged about what this court sees, how this court sees race, how this court sees the United States history of racial subjugation, and then make you kind of pessimistic about how we fix it and whether courts can ever be a part of that remedial process.
And why do you think um, criminal justice and these particular cases and this type of jurisprudence allows the court to step back a minute and acknowledge some of the, is it because it's written in like with Batson and some of these other um, kind of established case law, but we've also seen them not really care
Yeah.
about established case laws. So what is it about criminal justice you think makes some of these not progressive, but at least acknowledged racial decisions possible?
Yeah, so it's so I think a couple of things. One, I think there's the case of McCleskey versus Kemp, which was a 1980s decision in which there was all of this really powerful data about how race influences the death penalty process. Um, and the court there said, we can't take into account the kind of systemic claim because it would just undo the death penalty. And that's such a wild thought, right? Like the idea that there's just so much racism in this system that we don't want to address it or we can't legally address it because we'd have to undo the system. It seemed like that was a low watermark for the court, but I think it also meant that litigants started shying away from bringing kind of these systemic broadside racial challenges to criminal procedure and policing practices. Um, Especially because along the way, you had cases that either just wouldn't see how race operates in systemic fashions in the criminal legal system, or would say, but there are other reasons this happened independent of race. And so there's nothing to be concerned about. I think one of the reasons the court is at least willing to recognize some variants of race and racism in this kind of in the criminal law arena is that it's just not threatening to them and their worldview and their kind of imagined lives in the same way that other areas of law are, right? So if you think about affirmative action in colleges and law schools or what have you, I imagine they can very kind of viscerally feel, wrongly in my view, but feel that this type of racialized consideration disadvantages me and people like me. Or if you think about schools and busing and how we integrate schools, this kind of racialized action would affect how I would raise my child, or someone like me would raise my child. Or think about voting, same thing. This would minimize my voting power. But acknowledging the way racism operates in policing won't change the fact, or doesn't change the fact, I think, to their minds, that they will never experience policing, at least well, none of the justices at this point in their lives will never experience policing in the way that the average poor person of color will experience policing in many parts of the country. Um, and it just is so, I think it's so systemic. And it's never, there are very few kind of systemic challenges that the court sees to the way policing operates in a racialized way, that it doesn't unravel the way that policing happens in the United States. And I think if there were kind of broadsides against how we need the law to be able to tackle these kind of racial impacts, I think the court would resist it because it would undo this system that to them keeps people safe, where to others is deeply threatening and keeps them very unsafe. But in that kind of run-of-the-mill case where we can think about the past or think about the most egregious racism that you can confront, the court is like, well, we'll acknowledge that. I guess one final point is, I think the court, whether knowingly or not, every once in a while gives you a bone to kind of pacify you, right? Like, we're not racist because we just did X. Or like, we know we just got rid of affirmative action altogether, but look, last year we overturned a death penalty conviction based on this real racism. Like, that's what we're focused on. And so by doing that, it kind of, in some ways, gives them cover to do the other, what I would consider racial injustice work. That is like not acknowledging the many other ways that race plays into American society.
Yeah, and I want to, if we have time, I want to return to that and Thomas's dissent in the Harvard case, because
Yeah.
that takes on a whole new spin on what you were just talking about. But let's get into the cases you talk about. And
Yeah.
I was most interested in the Peña-Rodriguez case and the Flowers. But if
Yeah.
you have other what you want to talk about, um, let's just kind of walk through briefly what you cover and why you think they're important.
Yeah. So Peña-Rodriguez versus Colorado was a case in which the defendant in that case, who was Latino, was on trial for various offenses related to kind of sexual misconduct. And during jury deliberations, one of the jurors, who was an ex-law enforcement officer, just made a number of the most blatant, in the court's words, anti-Hispanic kind of stereotypical racist comments that you could imagine, including, he must have done this because he's a Mexican. You can't believe his alibi witness because he's an illegal, and just comment after comment after comment. And normally there's a federal rule, and every state has its own version of the same rule, that even if you learn about a juror saying outlandish things during jury deliberations, courts can't hear evidence about that. It's called a no impeachment rule. The idea being that jurors get to deliberate in secret. And it's part of them being able to kind of vote their conscience and being able to speak freely. And so we protect that, like we jealously guard that. And one way that we guard the secrecy of the jury is to prevent courts from ever hearing evidence of anything they discussed during jury deliberations. So, for example, there's this case where the jurors were literally drunk and high throughout the course of deliberations. One of the jurors described it as one big party, and the court said, tough. We understand that that may have impeded the defendant's constitutional rights in this case, but we don't receive evidence of this because the secrecy of the jury is more important. And so Peña-Rodriguez feels like a big deal because there the court held, okay, even if we have this rule, general rule of secrecy, like racial prejudice is just so special and so odious that we need this exception. And so we haven't carved out very many exceptions before, but we'll carve one out here for this type of racial prejudice. And that sounds great. And it is great. Like it shouldn't be the case that we are convicting people because of their ethnicity or race. But then if you dig a little deeper, the court sets a standard that's literally tethered to the type of kind of odious rank racism that you see in the decision, right? And so they say that racial bias has to be overt. Well, what does that mean? Is overt just the slur, or he had to have done it because he's a Mexican, or is it something more subtle? And then they say, and you need to show that racial bias motivated somebody's vote to convict. Well, how do we show that? Like, once you have expressed racism, how do I know how it affected your thought process? And in fact, all of the social science suggests that once we know people have biases, we'll never be able to fully measure how the biases affected decision making. So on one hand, you have a decision that proclaims these really important principles about racial prejudice should have no place in the administration of justice. On the other hand, you have the decision, if you dig into it, you're like, oh, but this decision actually won't work to that many people's benefits. And I've actually studied recently every single case since Peña-Rodriguez in which somebody had raised a juror bias claim. And there have only been two successful cases in the almost 10 years that this decision has been on the books. Um, and so that's one case I'm like, I have been thinking about deeply about, well, how do we leverage it despite its clear shortcomings? How do we figure out a way to leverage it for positive racial justice goods, which I'll be happy to talk about in a second. And the other place that you mentioned is kind of similar in that it is the most cartoonish form of racism one could possibly imagine. It's this. So Curtis Flowers was tried capitally in Mississippi by this DA, Doug Evans, who had the most obvious pattern of discriminating against Black jurors in his jurisdiction. And so Curtis Flowers, he was tried 5 times for the same crime before the case got to the Supreme Court. And every time the jury was diverse, they couldn't return a verdict. Every time the jury was not, they convicted him of capital punishment, of then sentenced him to death. And you had, and this is thanks to reporting in this amazing podcast about Curtis Flowers' case, where they found all of this data over the course of decades of this one prosecutor's use of peremptories, the strikes to remove jurors, and found just the most striking pattern of discrimination. And so the case gets to the Supreme Court and they say, of course, this is discrimination. Of course, we're going to reverse it. Of course, we can't let this happen. And again, they do it with these grand pronouncements about how racism in the criminal legal system is awful, and we will do whatever we can to root it out. And we have, the court says, we have been trying to root it out all along. But then you do it in a case that you'll just never statistically see again. And so it's really unclear. Like the language is wonderful, but like if you think about how you use it for its precedential value, unless you have years and years of statistical data plus trial after trial after trial after trial in a life or death case, it's not clear what the court would do with that. And so I think a lot of legal scholarship looks at those two cases and rightly views them very critically, kind of saying your walk didn't match your talk. Like you talk this big game, but like nothing about your movement in the law suggests you actually care about stamping out racism in all its forms, like you say. And so against these kind of really trenchant and I think correct critiques, that's where I try to step in. I'm like, yeah, let's grant them that. Like, let's all agree that these cases are, you can critique them from here until the cows come home. But what good can we do with them? And so that's where I try to intervene in this article.
Before you get into getting into the good that they can come out of this, I'd like you also to address what you cover at the end of the article, when like the gun rights cases, where they insert race where there is no race, and they act as though they're these protectors of Black rights and civil rights, where there isn't a challenge, I guess, where they're asserting an affirmative outcome that seems a little disingenuous, but also opens up an avenue. So could you talk just briefly about how the court does that and what the little rhetorical trick is they're using?
Yeah. So, this was part of Justice Scalia in many ways. He started this with Heller, where he said we need to interpret the Second Amendment consistent with its original understanding. And its original understanding also includes a long history of disarming then enslaved Black people. And so we fast forward to the end of the Civil War, and like now all of a sudden part of the Civil War, what if you were to read the court, part of the Civil War was allowing Black people guns. And that's what everybody was laser focused on. When you think of what the Civil War was designed to do, when in fact, immediately after the Civil War, there's also history about restricting guns because you had recalcitrant vigilante and just white governments killing black people. And so part of the project was to get guns off of the streets because they made black people unsafe. And so they choose this extremely one-sided narrative of what how to think about race and guns in the period around emancipation, and then use that to say, well, we can't restrict guns now because that looks just like how we restricted guns when black people weren't allowed them in the 1800s. And that to me is just mind blowing, right? And they do it, but okay, let's say that that is your view of history, right? It's one-sided, it's inaccurate. There's a lot of scholarship about that. But if you look about when they're willing to recognize a history today, they use it in cases where well-funded kind of civil rights groups and plaintiffs that are kind of designed to take challenges to the Supreme Court bring these cases to try and strike licensing regimes, right? But when criminal defendants try to raise these kind of racialized challenges, where if you look at some federal gun charges, a vast majority of gun crimes in the federal system are brought against black people and then Latino people. And then like way down in the bottom, you have like your white band of criminal defendants who are convicted of federal gun crimes. When people try to leverage that, you had some courts say, well, if we have to take account race and kind of what's happening, like this is part of this history of disarmament. You have the Supreme Court take Rahimi and they kind of walk it back a little bit. And it's just head spinning. But I think that is an example of, at least for a time, and it's not completely closed, and criminal defense lawyers are still trying to be creative, where the court kind of bastardized, excuse my language, for a lack of a better word, this history. But you saw criminal defendants really trying to leverage it for the good of the black and brown people who are being convicted of gun crimes most frequently every day. And so I think it's a perfect example of how we can kind of use cases that are bankrupt or impoverished in some way to try and do some real work. And Rahimi being a coda is not great, but people are still fighting and still trying to find their avenues. And I think so it is exactly that type of legal strategy that this article is really trying to push.
So using the two cases we talked about, Peña-Rodriguez and Flowers, could you talk about the avenues that those two cases push or open up, and how you kind of argue for a more robust, I guess, and conscious idea of how to push these counter arguments for.
Yeah. So I think it's really important that we have statements from the Supreme Court, whether you believe it to be acting in good faith or not, saying that we need to take seriously this idea that we need to stamp out racial prejudice in the administration of criminal law in a world where in all other areas of law, they're like, we don't see race. We don't want to talk about race. Don't tell us anything about race, right? And so if you're practicing criminal law and you see over and over again kind of the ways in which race impacts cases, whether it's the way people are policed, prosecuted, charged, sentenced, etc., you have language to kind of begin to have discussions about, well, look, court that I'm talking to, we need to talk about this and we need to figure out like how to undo this because the Supreme Court told us to, right? And like you may have a realist judge say, yeah, they didn't mean it, but like that's not their job. Their job is to say, well, I need to take this seriously, and kind of taking seriously the idea that racial bias is odious in all aspects of this system, forget other systems, but this one, then I should at least be able to have a discussion and make an argument about how race matters to a particular claim in this criminal legal system and what we should do about it. And when lawyers have been doing this and outside of the Supreme Court, but like in lower federal courts and especially in state courts, when lawyers kind of raise the idea that when my client runs from police, it may not be conscious of guilt. It may be that his race makes him genuinely afraid of what police might do when they approach him. Courts say, yeah. Some courts have said, yeah, you're right. I'm not going to take that into account. Like that is how race operates in this area. And so I'm going to kind of come up with a way to appreciate that and acknowledge that reality. Or if we have a Fourth Amendment seizure case where somebody's like, my client didn't feel free to leave because he knows as a young Black man from X neighborhood, that could be deadly. And some courts have said, you're right, like that is something we should care about and think about. Um, and so what I argue for somewhat cautiously is that what I think that this decisions do is open up room for conversations. And I think conversations that just have been lacking in the criminal courtroom for a number of reasons, including that I don't think lawyers have or had at least the facility to really have in-depth, nuanced conversation about how race was operating. I don't think we saw it for a long time just because it just was. But now that we have the language, we should be able to use that language in the courtrooms. And to those who say it's irrelevant or doesn't matter, I think the cases say, well, no, it does. And we do have to talk about this. The Supreme Court told me so. And until the Supreme Court kind of says it doesn't matter, which it might one day, I hope it doesn't, but it might. But until it does, you don't have the ability to just shut me down altogether. And so that's really my main hope from this case. Is they just allow us space to have realistic conversations about how race is operating in a case. And states just have, I mean, the Supreme Court sets the federal floor, and state courts can interpret their state constitutions to be much more protective and capacious in terms of how we think about rights and people. And so I especially hope that in state court systems, where judges do have more leeway to operate under the state constitution in most places, that they really take that obligation to have those discussions seriously. And I think some courts really are truly having very serious and nuanced discussions about race and racial bias in the criminal legal system that hopefully will do a lot of good, or if nothing else, will hopefully lead to a lot of truth telling, which I think is what the law has been lacking in so many ways.
Well, thank you for that. And I think that'd be a good place to stop, but we can't because we have to talk about Clarence Thomas.
Uh,
Because I think your fear about what the court might do is kind of epitomized in this Clarence Thomas concurrence in the Harvard cases, where he basically says, I don't know what diversity even is. Data doesn't matter. Your statistics can't be judiciated, whatever. And what is he doing? Why is this? And what's the threat it poses to your argument?
so I think Justice Thomas is a deeply interesting human. So I think Justice Thomas's view of race is complicated. And I think part of the reason he thinks race shouldn't be considered at all in most areas of constitutional jurisprudence is that I think he thinks it stigmatizes, and that it, if we consider race in certain ways, it puts a badge on somebody. And in his view, a badge of blackness is automatically connoted with a badge of inferiority in some way. And, I am not saying that he may not have come across that view. Honestly, I'm not saying like he may deeply and truly feel that way. But I think that motivates a lot of his race jurisprudence which again, I don't know if that neatly maps on to the criminal procedure context in the same way. But I think everywhere else, I think that's what drives, or I think that is a driving factor, I should say. I think the worrying part for me about Justice Thomas is a kind of jurisprudence, is that A, that's just not how everybody experiences the way that race works. Just because you view kind of the idea that somebody may have considered your race to make you feel less than in a certain kind of scenario. That's not true of every Black person. And some people view their race and want it to be considered as a badge of pride. Um, and the idea, and in addition to being not being proud of race, it also is just deeply wrapped into one's being in this country. Whether we like it or not, your race matters to some degree in some area of life. And as much as Justice Thomas may wish that weren't true, it is. And so kind of ignoring that, A, ignores the truth, but B, ignores the fact that not all people feel the same way as you do about how race operates and what it signifies when we think about somebody's race, which is why I think it's especially important right now to have Justice Jackson on the bench. Because I think when he was the lone Black voice on the court, it's hard to kind of push it back. Like when when the narrative seems so deeply personal, it's hard, I think, or I could imagine it'd be hard to kind of push back against that without risking some kind of like offense in some way. And so to see Justice Jackson saying like, no, this is part of my story and it's part of somebody's story and they can be proud of it and you should consider it. I think it's just so important in this moment where it's easy to kind of see his view and say, yeah, this is stigmatizing. We shouldn't be doing this to people. And they can take that view and think of it themselves as being benevolent, which I think is the big concern. Whereas like Justice Jackson's counterpart, like, no, it's actually malevolent to kind of strip somebody of their identity and not allow them to talk about it. Like that's malevolent. And so I think that's kind of part of what's happening here. Again, I think Justice Thomas just doesn't care for people who commit crimes, and so I don't think he'd be super receptive to any argument to be more defendant conscious in the criminal procedure context. But I don't know if he would be resistant. Well, I'm sure he would be, but the idea of stigmatizing in the criminal justice context just doesn't make as much sense because the stigma happens the moment you're over policed or over prosecuted on the basis of your race. And so if anything, it's the court giving you back your dignity by acknowledging the harms that have happened.
Well, do you have any avenues of hope, and do you see this having an effect in the court on the ground?
You know, I if you ask me if I have hope and I'm only thinking about the Supreme Court of the United States, I would say my hope is at a minimum. But I will say, and there are state Supreme Courts, and state trial judges, and federal appellate judges, and federal trial courts who are doing awesome, righteous, thoughtful work, and they're doing it even in the face of a Supreme Court that feels hostile to any kind of project of ensuring a fully fledged and flourishing multiracial democracy. And so that gives me hope. It gives me hope that there are judges who are willing to see what the Supreme Court is doing and say, okay, I know I have to follow the court, but where I can chart a different path, I will. And so I think that is hopeful to me. And I hope as different generations get to the bench, and as we've been having these conversations in more robust, real ways, which is why I truly appreciate being able to talk to you about this. I truly hope we'll just have generations of judges that are willing to kind of grapple with the realism of jurisprudence and not just pretend that certain things don't matter.
Thanks for listening to the Unpacking 1619. For more information on Heights Library's 1619 Project discussion group, or to check out more interviews with scholars, please visit heightslibrary.org. See you next episode, wherever you listen to podcasts.